Well, good evening, everybody. It's so good to see all of you this evening. I'm Teresa Jenkins. I'm chair of the Public Programs Committee with your League of Women Voters of Greater Tucson. So, our committee, our Public Programs Committee, is devoted to informing our membership about the effects of policies created at the national, the state, or the local levels and the impact that they have on our communities.
It's really
Tonight's
sweet.
program is devoted to informing our membership about the effects of policies. I'm hearing some background noise. Could everybody make sure that look down at the bottom of your screen? It says audio, and you want to make sure that that is on mute. And we'll mute some people if we need to, but if you could take care of that, that would be fantastic. Thank you. Okay, tonight's program. It has been created in partnership with the League of Women Voters of Greater Tucson and the Tucson Committee on Foreign Relations. And it will address current threats to national security and the rule of law, a very timely topic considering the use of our military abroad. Before we begin, though, we are honored to have with us this evening the president of the League of Women Voters of Greater Tucson, Betsy Bozia, who would like to say a few words.
Good evening, everyone. Thank you, Teresa, and thank you, Bill, and thanks everyone for joining us. Very briefly, a few words about the League of Women Voters. We are a nonpartisan political organization encouraging informed and active participation in government. We neither support nor oppose candidates or political parties at any level of government. We do, however, advocate for public policy such as voting rights, non-discrimination, civil rights, reproductive rights, and criminal justice reform. We've been empowering voters and defending democracy in Greater Tucson for 84 years. So thank you all for joining us for this program this evening.
And thank you, Betsy, for being here this evening and for your leadership. So now let me turn this program over to our moderator, Marge Huey, who created tonight's program, and she will introduce our speaker.
Thank you and welcome everybody. The League is co-sponsoring this event with the Tucson Committee on Foreign Relations, which is a nonpartisan educational organization that hosts expert speakers on U.S. national security and foreign relations. If you would like more information, please visit our website, tcfr.org. Flood the Zone is the articulated strategy of the Trump administration to create chaos and keep its opponents off kilter while implementing its change agenda. We have seen the unorthodox use of governmental power in spheres as varied as government restructuring, immigration enforcement, military activities, higher education, and the judiciary. Today, we have invited Bill Banks, constitutional scholar and national security expert, to help us make sense of the immediate and longer-term implications of these actions. Bill is a professor emeritus at Syracuse University College of Law, founding director of the Syracuse University Institute for Security Policy and the Law, chair of the ABA Standing Committee on Law and National Security, and editor-in-chief of the Journal of National Security, Law, and Policy. You may have also seen him or read about him in various media as a national security expert. And I have just listed a very few of his many accomplishments. After Bill speaks, you'll have an opportunity to ask questions. Please submit your questions in the chat feature, which we will be monitoring. Bill, it's all yours.
Thank you, Marge, and thank you, Teresa and Betsy. It's a pleasure really to be with this group, the combined League of Women Voters and TCFR. I'm comfortable in this Zoom environment. Indeed, I teach classes routinely on Zoom, but it's not as good, is it? I wish we could be in person and face to face. Marge mentioned flood the zone. The metaphor that I've been most comfortable with for the last year is drinking from a fire hose. It's nonstop. It's overwhelming. And even though I've been in this business for a long time, since the 1980s, I've never seen anything like this in terms of the pace of change, the degree to which actions of our government are violating the law and testing the law in countless ways that we as Americans have never seen before. We can't talk about it all this evening, and I've picked out a couple of things that I know that you're familiar with, at least to give us a framework for a discussion. I'll probably go back to a few of the ABCs to talk about the legal structure for national security decision making in the United States, and I'll try to keep my remarks at a half hour or so so that we have plenty of time to engage in a discussion in as much as we can in the Zoom format. You all know that last week, I think it was Monday last week, Pete Hegseth, the Secretary of Defense, directed the Pentagon to investigate Senator Mark Kelly. He was a retired Navy captain who flew combat missions during the Gulf War, took several space flights as an astronaut before he was elected to serve Arizona's citizens in Congress. What was his potential crime? Telling members of the armed services that they do not have to follow illegal orders. Problem, of course, is that saying so is not a crime. It's a true statement of what the law is. President Trump doesn't like it, but what Senator Kelly and his colleagues said is protected by the First Amendment. In a video that was released last week as well, Senator Kelly and other elected lawmakers reminded members of the military that they can, quote, refuse illegal orders. That's exactly right. Following orders is not a defense if you follow an illegal order to commit a war crime. Think of the Allied prosecutors establishing at the Nuremberg trials of Nazis after World War II. Members of the military have not only the right, but the obligation to refuse illegal orders. Well, the video enraged President Trump, who likes his orders followed, of course, whether they are lawful or not. And on his social media platform, he called the video seditious behavior punishable by death. He went on from there. I won't continue with the other superlatives that he added to that comment. If anything is lawless in this immediate context, it's the investigations. The video itself mentioned no particular orders. On Face the Nation, a few days later, Senator Kelly, who's a member of the Senate Armed Services Committee, questioned the legality of the orders. That's what I'm going to talk about next. But on that point, Senator Kelly is echoing what a lot of other experts, including me, have been saying about these strikes. That's probably the main question that I'll get to next. I'm going to talk about the strikes for a little bit, and then I'm going to talk about the domestic use of the military and the deployment of National Guard in our cities, troops on the streets. I think those two topics might take us through most of the time we have together. It's hard to find anyone outside of the president's inner circle who considers the killings that occurred in that early strike on Caribbean boats legal. They've declined to discuss or release publicly a memo that purported to advance a legal rationale for the strikes. I'd love to see it. I can pretty well predict, I think, what it says, and it would be embarrassingly outside the mainstream of legal opinion. I think legal experts on the law of war, national security, defense, the military, almost to a person, have agreed that the rationale that's been offered for these strikes in the Caribbean comes up short. Why is that? here's the question that it's been asked pretty starkly here in the last days. Is it legal to use force, lethal force, to target suspected drug trafficking boats on the high seas or to kill those who are on board the boat? The answer, no. The United States is not in an armed conflict with any cartel or any criminal gang. That means the law of armed conflict, which is the law that the administration has asserted is involved here, also known as International Humanitarian Law or IHL, does not apply to any of the military operations that began on September 2nd. The domestic criminal law and international human rights law both prohibit these kinds of lethal strikes, and they also uh, forbid uh, any strikes outside of an armed conflict. Outside of an armed conflict, those kinds of killings are called either murder in U.S. law or extrajudicial killings, if you like the international law version. All 21 strikes to date against suspected drug trafficking boats that have killed 83 people to date have been unlawful. So a follow-up question might be what U.S. law does apply to the lethal strikes against those boats and the people on them? It's peacetime law. We are not at a war with the cartels. We're not at a war with the drug traffickers. Federal laws prohibit murder and conspiracy to commit murder. And under U.S. domestic criminal law, the unlawful killing of a human being with malice is murder, including when committed on the high seas. That same law also applies during armed conflict. The Uniform Code of Military Justice also criminalizes murder, both when military personnel intend to kill and when they engage in an act which is inherently dangerous to another and evidences a wanton disregard of human life. It applies here in the US, that provision. It also applies overseas. It applies during armed conflict when the death is not lawful under the law of armed conflict. So, what about international law? International human rights law applies to US strikes on suspected drug traffickers. They're called extrajudicial killings. That's the arbitrary deprivations of the right to life under IHL. That's an obligation that the United States has long acknowledged, and it applies extraterritorially. A lot of big words in this talk. Killing is arbitrary when it's not conducted in self-defense or defense of others against the imminent threat of death or serious injury, to prevent the perpetration of a particularly serious crime involving grave threat to life, to arrest a person presenting a danger or resisting that authority, or to prevent his or her escape, and only when less extreme means are insufficient. None of those circumstances were present in the boat strikes, and particularly because those killed pose no imminent threat, and other means of stopping the boats that are commonly used may have been feasible, such as simply stopping and interdicting the boats on the seas. States violate international human rights law, not individuals. Individuals involved in those violations can be punished for murder or conspiracy to commit murder. The arguments made by the administration that the United States is in a non-international armed conflict in the rubric of the laws of war, it's called the NIAC, non-international armed conflict, those arguments are fallacious. You can't be in an armed conflict with a criminal gang. You can be in an armed conflict with an armed group that has sufficient strength and armaments and is carrying out violence against another state. These guys, if they're doing anything, they're supplying cocaine in the United States and making a lot of money. Yes, they have weapons, but the weapons are probably used more for their own criminal enterprise. They're certainly not engaged in any kind of conflict with the government of the United States. the violence that would lead to an armed conflict has to be sustained and protracted and intense. Sporadic violence that may have occurred in drug operations is not intense enough to cross the threshold for an armed conflict. So that leads us to the question for just a moment. What about those who are on the boats? They're civilians. And if they're civilians and we're not in an armed conflict, they are legally required to be protected, not targeted. They certainly can't be directly targeted with lethal force. Even in an armed conflict, those on a vessel are deserving protection from violence unless they themselves are participating in an armed attack against the United States. So killing the shipwreck survivors on that vessel in early September, that was clearly unlawful. Whether the order was given by Secretary Hegseth or by the General Admiral who was commanding the operation for the military, either way, they're unlawful. And targeting those individuals with lethal force in the first place, this is in the rubric of the military called a double tap strike because the first missile didn't kill everyone on board, as Secretary Hegseth apparently ordered before the first strike was undertaken. He says he left the room and didn't see the video of the second missile that killed the two survivors. Whether or not that's true, he seems to be trying to foist the blame onto the admiral who carried out what he said was the order from Hegseth to kill everyone before the first strike. So, what are the ground rules? In the United States, let me back up to a little bit of history. We in the United States, I'm gonna share my Zoom screen with a couple of PowerPoint slides from the old days. Um, when we engaged in a revolutionary war and sought our independence from Britain in the 18th century, we we were facing challenges once we succeeded in gaining that independence. We were facing challenges about what kind of a system we could create for ourselves. Are you seeing John Locke? Yes.
Yes.
The the English system, as you know, at the time was a system based on the royal prerogative. And almost all powers over war and peace and foreign relations were for centuries vested in the executive branch of government. Executive branch of government in England, of course, was a king. And the political and legal theorists who were prominent in Europe in that period of time were people like John Locke. And look what he said about executive power. All foreign policy powers were delegated to the executive. They were, in those days, often known as federative powers. Look at what they consist of. The power of war and peace, leagues and alliances, all the transactions with all persons and communities without the Commonwealth. And he went on to say, these are paraphrases from his treatises, any attempt to separate the federative power from the executive would invite disorder and ruin. If that weren't enough, the other guy who was probably equally influential in England and in the colonies at that time was Blackstone. And Blackstone, see if I can get him up here.
Yep, he's there.
He's there. Look at what Blackstone had to say. King had the right to send and receive ambassadors, make treaties and alliances, make war or peace, issue letters of marque and reprisal, command the military, raise and regulate fleets and armies, and represent the nation in its intercourse with foreign nations. Well, you know, when the United States went to war with the English, the Declaration of Independence said in its predicate, the chief complaint against the crown was that they had rendered their military independent of and superior to the civil power. We were fed up with the crown. We were fed up with heavy-handed use of the military in the colonies. That was the first incentive for independence. As you know, the war was brutal. The war went on for a long time. And when it was over and we had a country, we had to decide what kind of government to make. It's unsurprising that even though the systems in Europe and the New World at the time heavily favored the executive control over foreign affairs and national security, our framers wanted to have nothing like that. We were determined to take the powers that had been invested in the English crown for centuries and transfer most of them from a single executive, which we didn't even have until the Constitution was drafted and ratified, transfer them from what became the President of the United States to an elected Congress. So in our Constitution, let me get a couple of provisions of the Constitution up here. There we go. Here are the things in the Constitution that the framers decided should be in the hands of our Congress rather than the president. Congress has the power to make rules for the government and regulation of the land and naval forces, provide for calling forth the militia to execute the laws of the Union, suppress insurrections, repel invasions. Keep that provision in mind when we talk about the domestic stuff in the National Guard in a little bit. Provide for the organizing, arming, and disciplining of the militia, governing such a part of them as may be employed in the service of the United States. Let's go on. Here's the punchline, of course, is Congress has the power to declare war, grant letters of marque and reprisal, make rules concerning captures on land and water, pay the debts, provide for the common defense, raise and support armies, prevent and maintain a navy. And I think the penultimate or the ultimate one on my list here is next. Yes. Define and punish piracies and felonies committed on the high seas and offenses against the law of nations. Here are the president's national security powers in Article 2 of the Constitution. Bear with me, it's a shorter list. The executive power shall be vested in the President of the United States. The President shall be Commander-in-Chief of the Army and Navy of the United States when called into the actual service of the United States. He shall receive ambassadors and other public ministers, and he shall take care that the laws be faithfully executed. Well, you can see that the lion's share of national security of powers, I'm going to stop the share here just in a moment. Let me see. Stop share. Here we go. Am I back? Yes.
Yes.
Okay, thank you. As you can see, what our framers did was to literally transfer the bulk of national security and foreign affairs powers from an unelected, at the time, king to an elected U.S. president, but to the Congress, and leaving only some national security and foreign affairs powers to the president. Since we're in the weeds here, let me say one other bit about our history. There was a period in the Constitutional Convention in Philadelphia when the framers were debating these very issues. And the debate was over the Declare War Clause. That's obviously the foundational one, and it bears upon a lot of the events that we're talking about this evening. The debate concerned whether to leave the language as it had been in the Articles of Confederation. The Articles of Confederation gave the Congress the power to make war. At the debates in Philadelphia, on the day that that provision was being debated, James Madison stood to object. He said, I think make war is too cumbersome. let's change the verb from make to declare. And here's what he said next: leaving to the president the power to repel sudden attacks. There was debate, there was discussion. It went on for most of the day. There was a decision at the end of the day, indeed, to switch the language from make to declare. And that parenthetical addition by Madison didn't make it into the text of the Constitution, but it was the understanding of the delegates in Philadelphia that what the framers had done was to vest control over offensive uses of force in the Congress, leaving it to the president the power to repel as a defender on behalf of the United States. If you think about it, that makes a great deal of sense. And indeed, that's what happened for more than most of our 250 plus years, is that the Congress made deliberative decisions about when the United States should engage in war. The president retained the authority as commander-in-chief to repel sudden attacks. Primary example, Abraham Lincoln, the Civil War, the attack on Fort Sumter. He wasn't expected to go to Congress, which wasn't even in session at the time, to obtain a declaration of civil war. He was expected to repel the attack on Fort Sumter. He did. George Bush on 9/11. Did he need a declaration of war? Of course he didn't. We were attacked viciously by Al Qaeda and Taliban supporters in September of 2001. He had not only the power, but the duty to repel the sudden attack with all the force the United States could muster. The contemporary problem, and this feeds back to the drug boats, is this. The war-making powers of the president in the 20th century and the early years of the 21st century have overtaken the war-deciding powers of the Congress. Over time, Congress's powers have slipped away into the hands of willing presidents who have used them in all kinds of circumstances, beginning with President Harry Truman in the Korean War in 1950. You all know from your study of civics as kids in school that the last time the United States engaged in a declared war was World War II. It was Romania in 1942. We haven't declared war since. No nations declare war now. Wars just happen. In our system, they're supposed to happen following a declaration or some other authorization from Congress. Congress has on occasion responsibly done that, such as the AUMF that was passed and enacted a few days after 9/11. But by and large, the war-making power has accreted, devolved, moved laterally into the hands of aggressive executive branch actors, and most national security initiatives by the United States have now been undertaken at the behest of the president, like the drug strikes, the boat strikes. Are they lawful? I've already said why they're not. These aren't even close cases because we're attacking criminal organizations, not armed groups. And it seems to me that there's not a federal judge in the United States who would find that the president had lawful authority to undertake strikes against these boats in the Caribbean. Okay, it's 5:30. Maybe I should switch to the domestic side and talk a little bit about the domestic use of the military and and the use of the National Guard troops, and take 10 or 15 minutes and then stop for questions. Betsy, does that seem like a reasonable thing to do? Good. You know, when in his inaugural address on January 20th, President Trump promised to, here I'm going to quote briefly, launch the largest deportation program of criminals in the history of America, end quote. He also stated they would, quote, send troops to the southern border to repel the disastrous invasion of our country because as commander-in-chief, I have no higher responsibility than to defend the country from threats and invasions. Well, the president issued 10 executive orders on that day, January 20th, 2025. One of them was called declaring a national emergency at the southern border. Another was called protecting the American people against invasion. You've seen this invasion rhetoric from President Trump throughout the year. It's not an accident because the president is actually quoting or paraphrasing loosely from a statute called the Alien Enemies Act. The Alien Enemies Act was one of four components of the Alien and Sedition Acts that were passed by Congress in 1798. That's right, 1798. We were at that time, ironically, on the brink of war with France, and the dominant Federalist Party feared that non-citizens living in the US might sympathize with France and threaten domestic security. So the Alien Enemies Act allows the president to invoke it if Congress has declared war. That didn't happen. Or if the president proclaims an invasion or predatory incursion by a foreign nation or government. Once the act is invoked, the act authorizes the president to detain and deport any such non-US citizens who were born in that nation, including those lawfully present in the United States, regardless of any reason to suspect that they're dangerous. The only time the Alien Enemies Act has been used in any of our lifetimes was during World War II. Most of us weren't around then, fortunately. And they were used then the act was used then to intern tens of thousands of non-US citizens, Japanese, Germans, and Italians. And they were detained at military facilities. These were not the internment camps because those individuals, they were Japanese Americans, not foreign nationals, and they were separately authorized and then embarrassingly upheld by the Supreme Court. The strongest argument that the Trump administration has made is that migration from Mexico or from other Latin American countries amounts to an invasion or predatory incursion at the behest of drug cartels that operate as de facto governments in those regions. On that theory, the Alien Enemies Act would permit him to deport Latino immigrants who are undocumented or involved in criminal drug activity, indeed, even if they are legally present in the United States. Now, the Alien Enemies Act standing alone does not authorize military participation in law enforcement, but other laws have been thought by the president and his administration to support the Alien Enemies Act in practice. As many of you know, the United States has been historically respected for our tradition of entrusting civilian law enforcement to cops, to federal agents, to local and state police, to sheriffs, constables. Our uniformed military are designed and enlisted to fight wars and keep us safe from foreign adversaries. Only episodically are military needed for any domestic assignments at all. Those traditions are reflected in the Constitution. They're explained in part by this antipathy that we had as early Americans to the heavy-handedness of the English crown and the heavy-handed use of the British military in the colonies. The Congress was empowered in the Constitution to call forth the militia. That's what the National Guard was called in those days, to, quote, repel invasions. But that grant of authority was understood to anticipate the possibility of war being brought to the United States. One other piece of background law, and I'll talk for a minute about these recent Guard deployments. In 1878, Congress passed another law. This one you can use if you don't know it. You can use it with your family and friends over dinner tonight if they haven't been in on this conversation. You might You might impress them. It's called the Posse Comitatus Act, the PCA. The Posse Comitatus Act created a statutory presumption against military participation in law enforcement. It was a big deal when it was enacted, 1878. It's unchanged today. In fact, it's been expanded to apply to all the service branches. All parts of the military are impacted. And the basic presumption is that the military can engage in any domestic law enforcement unless some other law specifically authorizes it. So there's an argument now about whether the Alien Enemies Act is such a law. I've argued in a couple of things I've written this year that it's not. And that's part of what the legal basis was for the operations that the Trump administration has undertaken in some of our cities this year. Los Angeles, you remember, last June started as a small deployment in response to what the president claimed were violent protests outside of ICE facilities and attendant ICE immigration enforcement actions in the Los Angeles area. Small deployments were made of National Guard and then later some regular military by the president on the basis of a statute that allows for protection to be provided to federal resources in a designated place. If you paid attention to the news during that period in June, mostly last year into July, there was footage and a lot of still photographs that showed those members of the military deployed and standing around with nothing to do because the background principle of posse comitatus still applied. They weren't allowed to engage in law enforcement. They couldn't arrest anybody. They couldn't detain civilians who were protesting ICE enforcement operations. They could only protect federal facilities. If demonstrators were trying to burn the post office, for example, or interfere with an arrest, they could stand in the way of those protesters, but they couldn't arrest them or detain them in any way. There were court cases so far. The activities in California have been enjoined by federal courts there, and there is an appeal that's ongoing at this time. Meanwhile, the same basic script was being played out in Portland, Oregon, where again a deployment was proposed by the president. The governor of Oregon, just like the governor of California, said no, thank you. We've got things firmly in hand here. Our law enforcement community is responding to these operations with success. And then a few weeks later, the script repeated itself in Chicago, Illinois. Again, a deployment was urged. It's a crime den. It's a hellscape, said the president. And the governor, Pritzker in Illinois, said, thank you very much, but we too have things well in control here in Illinois. And we don't want you, we forbid you to send the National Guard to Illinois or any other military forces. Those matters, Oregon and Illinois, are now being litigated in the federal courts. There's indeed an appeal before the United States Supreme Court that may be decided by the court before the holiday this month in a very preliminary way about the lawfulness of the president's order to deploy guard forces to Illinois. That's a long-winded but very brief overview of the situation there. I believe that the states have the better legal arguments in all three of those cases because in our federal system, decisions about the use of the National Guard are at their core to be made by state governors, not the President of the United States. Aside from this narrow exception about providing protection to federal properties that I mentioned in the LA situation, the only other law that would allow the president to federalize a response to an incident in a city is called the Insurrection Act. You've probably heard about it. The Insurrection Act is like when all hell breaks loose. The Insurrection Act was first enacted by our Congress in 1792. It's been revised dozens of times in 250 years. The earliest iteration of the Insurrection Act was called the Calling Forth Act, and it was utilized, you learned this in fifth grade, by President George Washington to put down the Whiskey Rebellion in Western Pennsylvania when the distillers there didn't want to pay the tax on the spirits that they were making, and local law enforcement was unable to persuade them otherwise. So Washington called forth the militia from surrounding states into Western PA. As soon as the distillers saw the size of the force that the president had deployed, they gave up, and all was safely order was restored, I think, without any serious casualties. That law has been around for that long, and it's been revised a number of times, but its modern version, which is really unchanged since the Civil War for all practical purposes, essentially lets the president federalize any military incident if he finds that it's impracticable to enforce the laws of the United States. What's President Trump thinking about? He's thinking about immigration laws and the challenge that ICE is having to enforce their discretion to round up people who are not in lawful status in the United States and remove them by deportation proceedings. It's not a great argument, but unfortunately for all of us, the language of the Insurrection Act is so broad, the discretion that's given to the president is so extensive that many of us, I'm one of them, believe that he could utilize the Insurrection Act to federalize immigration enforcement in Chicago, in Portland, in LA, in New Orleans, as he's threatening to do now, and any other city in the United States. It would be a terrible thing because it would federalize an incident, it would bring in federal military, it constitutes an exception to posse comitatus, if you're following me here. Remember, posse comitatus is a presumption, not a barrier. And the presumption can be overcome by another law. The Insurrection Act is another law that specifically provides, in some circumstances, for military involvement in law enforcement. So they could come in, they could enforce the laws, they could stop citizens on the street, they could be traffic cops, they could routinely go to people's houses and ask to see inside. They're not trained or equipped for law enforcement operations. They're not trained to protect the civil liberties of citizens. They're trained to fight and win wars, and they're pretty darn good at it. But domestic law enforcement is not in the military toolkit. They don't like to do it. They are schooled in posse comitatus in basic training and in officer training. They dislike these kinds of operations. The president has been threatening to invoke the Insurrection Act since January 20th. It's in his inaugural address, if you go back and take a look at it. And he's talking about it now routinely. I don't know why he hasn't done it yet, but many people think that it's only a matter of time. The last time the Insurrection Act was invoked by any president was in 1992, following the acquittal of the cops who beat up Rodney King in Los Angeles, 1992. Rioting broke out after the jury verdict acquitting the cops in that situation. The rioting in Los Angeles became very bad, very extensive, lots of property damage, fires over extensive parts of Los Angeles, many injuries and deaths. The governor of California at the time, Pete Wilson, deployed the Guard locally, had all the law enforcement personnel that he could bring to bear. It wasn't getting the job done. He called the President of the United States, George H.W. Bush, asked him to invoke the Insurrection Act. The president agreed. He did so. Extensive military, Marines, and Army from Fort Ord and Fort Pendleton were deployed immediately to Los Angeles, and in a matter of days, the rioting was quelled and peace was brought to LA. Not without lots of disturbance and casualties, by the way. So 43 years, the act has not been invoked. There's a good chance we'll see it sometime in this Trump administration. Why don't I stop? That's 45 minutes of nonstop blather. I'm sorry to have gone on for so long. Uh, can I open the chat and see what we've got here?
Yeah, there's a few questions in the chat.
Okay. Let me start at the what I guess is the top. Thanks for joining us. That's welcome. Why doesn't the U.S. recognize the jurisdiction of the International Criminal Court? Well, do you think that the U.S. should be a member? To the latter question, I think we should be a member. Most nations of the world are members of the ICC. We've been worried. The government of the United States has justified our not being a part of that organization by fear of criminalization of our national security activities abroad, that our service members or even some civilians might be criminally charged and served in international courts to face consequences for following United States national security policies. It's an embarrassment in many ways that we're not part of the ICC. But as you know, if you've followed its activities over the years, the court has struggled to gain legitimacy across the globe. In many parts of the world, it is a viable organization, but having the U.S. not be a part of it and having us openly rebel against their asserted jurisdiction has not done them any favor. Next question. It seems that foreign policies become privatized by Kushner and Wyckoff for self-enrichment. Do you agree? Yeah, I do. Uh, there are laws that purport to stand in the way of self-dealing in our government, but who stands ready to enforce those laws? Members of the executive branch. It's self-policing, isn't it? And it's very difficult to achieve that. We do have inspectors general, and indeed, if you've paid attention to the news today, you see that there was an inspector general report inside the Pentagon that said that Secretary Hegseth misbehaved when he let classified materials release to persons not entitled to receive them on a signal chat early in his term as secretary. Well, that's an inspector general's report. What will come of it? Probably nothing. And Hegseth, of course, said that he declassified the information immediately and it did no one any harm. He may well be correct about that. What more can an ordinary citizen do in this environment? The capitulation of Congress to Trump et al. And the replacement of the entire national power structure with Trump loyalists, total disregard for law, and the seeming prejudice of the Supreme Court. I'm afraid I share those sentiments, Don Jack, and I have to keep faith. This is my livelihood. I've been doing this for more than 4 decades, and I believe in the rule of law. And I do think that the rule of law will prevail eventually. We may need a new administration because this one certainly isn't showing any signs of abiding by the rule of law. The last part of his question talks about the seeming prejudice of the Supreme Court. I'm not willing to say that yet. And I say yet. And if you pay attention, a lot of judges are applying the brakes to the Trump administration. I think there are more than 200 federal district court decisions this year in 10 and a half months that have said no to Trump administration actions, more than 200. And that's a majority, by the way, of all the attempts that they've had to second guess. Those have all been appealed. The record on appeal is mixed. The Supreme Court has not definitively weighed in yet on any Trump administration initiatives, aside from a few preliminary decisions in what we now know euphemistically as the shadow docket or their emergency docket. There are a few pending cases that are going to be very important in the coming weeks and months. One of them, was argued last month, was about the tariffs, the global tariff program by President Trump. If you paid attention to the news leading up to the Supreme Court arguments, you see that the three lower courts that heard challenges to his tariffs have all said that they're unlawful. I think that the deck is stacked against the Trump administration in the tariffs case. The arguments in the Supreme Court did not look favorable to the administration's legal positions. I counted at least 5 and maybe 6 votes against the president here. And if that happens, if they issue a merits decision against the president, that will be a very big deal. That decision, by the way, when it comes, will be based in part, or probably in major part, not on the constitutional powers of the president, but on authorities not delegated to him by Congress in a statute called the IEEPA, the International Emergency Economic Powers Act. We call it IEPA. You know why. IEPA confers extensive powers on the president, but it says nothing about tariffs. And if I went back and pulled up some more slides about the powers of the Congress, you'd see that the authority over commerce, international and domestic, is expressly given to Congress, not to the president. Many commercial powers, economic powers are delegated by the Congress to the president, but no mention of tariffs anyway. There are a couple of other major decisions on the docket this time that implicate national security affairs, birthright citizenship. We'll see how that goes. It's been quieter, and the noise that's coming from inside Washington is that the administration may be backing off President Trump's enforcement of President Trump's executive order here, thinking that they're going to lose on that one too. If they allow that argument to go forward and make it before the Supreme Court, probably in January or February, they could be 0 for 2 in the spring. The other decisions that implicate national security that are before the court this term involve the removal of executive branch officials. The Federal Reserve, the Federal Trade Commission, and other important agencies where officials have resisted the president's request that they resign so that he can appoint a new official. That's an important question too for national security affairs, not as directly involved. It's unlikely that any of the things that we've been talking about this evening are going to get to the Supreme Court anytime soon. For one, the Supreme Court tries with all its might to avoid decisions about the war powers. They haven't made many important decisions about the war powers. And about the domestic use of the military, even more so. They like to stay away. They want those decisions to be made by the elected branches for we, the people, to work it out. Maybe that will happen. I'm hoping that cooler heads prevail on these Guard deployments in these states. Indeed, the local officials in Illinois, in Oregon and California, other states where there's been controversy, by and large, the locals are handling any civil disturbances with the resources at their disposal. They have equipped units of state deployed National Guard that are trained to respond to civil disturbances, that are trained to respect the civil liberties and rights of the civilians in their neighborhoods and communities. And it's overkill and counterproductive, I think, in almost every circumstance to utilize a federal military force. Let me go down the list of questions here. How does the unitary executive theory interact with the current situation? Technically, only the executive, but given Congress seemingly ceding its powers, it appears to have expanded the approval of the court. Well, that's sort of what we've just talked about. That's a very good question. The so-called play Project 2025, was that what it was called, that we all read about before Trump was elected and then when he was inaugurated? That's essentially the unitary executive theory on steroids and with much more detail. I think we're seeing the unitary executive theory play out for 10 and a half months in 2025 with only a little pushback from the courts and none from the Congress. Congress, of course, has not even been part of the conversation. In what ways can the actions of the president in shooting the boats be challenged in court? Well, there are challenges being brought by survivors and by organizations who represent the cartels or those operating commercial interests operating some of the boats. Whether the courts will intervene is a good question. Would I? Well, I think that we're probably not going to see much of a judicial response to the boats. I think public opinion and excellent work by the media in this space is going to do more to curtail unlawful uses of military force abroad than anything that judges are likely to do. And as you can imagine, if you've paid attention to these issues in the media, regular members of the military are aghast at these activities and what they're being ordered to do. I have a lot of friends in the military and many more who are veterans who are just outraged at these activities. And I think that that kind of pressure from active military as well as from veterans organizations and influential members of the national security communities, past and present, is probably going to do more than the courts in this space. Would I comment on the politicization of DOJ? Oh boy. The Sunday New York Times Magazine talked about the Department of Justice becoming the president's private law firm. That's what it is. It's an excellent piece by Emily Bazelon and someone else in the Sunday magazine. It's in an interview format, and it just it ticks off all the ways that the department is simply doing the White House bidding. There's no more independence. And that's a really strong frontal assault on the integrity of the executive branch right there. If you can't trust the Justice Department or the Attorney General to have neutral principles to apply to legal situations, then there's no confidence anywhere. The pardon power, that's our fault, folks. We put it in the Constitution and we've left it untouched. I'm thinking of asking for a pardon. You all should too. If you contribute, I don't even want to joke about this. This is ridiculous. But there's nothing any of us can do about it other than to amend the Constitution to change the language of the pardon power. It's an extreme embarrassment that he's pardoned. And pardoning the former president of Honduras, who's one of the biggest drug traffickers of fentanyl, while we shoot at boats that are moving cocaine to Europe? In what world does that make any sense at all? Can I imagine the admiral ignoring his naval knowledge, his law of the sea, and shooting members just because he was told to? Yeah, I mean, who would want to be the admiral in those circumstances? Mutiny is never legally appropriate. There are mechanisms inside the UCMJ to challenge unlawful orders, and that's the process that members of the military who are still members of the military have to follow if they believe they've been asked and ordered to do something that's unlawful. That's true of the admiral. It's true of any enlisted person. Mutiny is never allowed, and indeed. In the context of the boat strikes, Admiral Kelly, Captain Kelly rather, because he was a long-term member of the armed forces, he could, under the UCMJ, be subject to military jurisdiction as a retiree. None of the other Congress people who signed on to that statement served a lengthy enough period to be amenable to continuing jurisdiction of the UCMJ, but it's of no significance in Senator Kelly's case because he didn't violate any law. He followed the law. Uh, border control people, border control people, here we go, are using military tactics to pick up immigrants. Is there any way to stop that type of extreme behavior? One of the things that's going on, this is from Marge. Marge, one of the things that's going on, I didn't have time to get to this. There are agreements that were authorized by statute from the Department of Homeland Security. They've been going on since even before the first Trump administration. I believe they were originated during George W. Bush administration to allow DHS to contract with state or local governments to loan officials, contract with those governments to provide more person power to DHS agencies, including ICE. And that's what's been going on this year in full force with the agreement of state governors. States can furlough personnel from any of their state agencies and be given some kind of training by the Department of Homeland Security to engage in various activities, including immigration enforcement. And I think what's happening with Border Control and ICE is that they are bringing people on who are either not trained at all or who are given very little training, either as new hires or as temporary transfer employees from the states. One of the things to notice about that, since we all live in Arizona, is that Arizona is not participating. These programs are done voluntarily with the support of state and local governments. So you can tell just by looking at a map where these agreements between DHS and the states and the cities are taking place in the red states. There are hundreds of these agreements in Texas and Kentucky and Florida, et cetera, but not in Arizona, not in California, not in Oregon, not in Illinois. So DHS has to go it alone. Here in Tucson, when ICE goes about its business, they can't deputize Pima County sheriffs or Tucson police. They can't deputize personnel from the state of Arizona because the state of Arizona has not signed one of these agreements. But state of Texas and many other states have. I think that gets to the last question.
Bill, thank you very much. Appreciate tremendously the information you've conveyed. And thank you on behalf of all of us.
It's good to be with you all. Thanks for being with me.
Well, I'd like to say also thank you so much, Bill, for spending time with us this evening, for sharing your knowledge with us. And I have a feeling that we'll need to have you back because there will be much more to explore.
You know how to find me.
Absolutely. And thank you, everybody, for spending time with us this evening and for your great questions as well. So have a wonderful holiday, and public programs will be with you next year. So have a good evening. Good night.
Good night. Thank you.